And the reason we are not also going live this time is because due to persistent network issues, it just did not seem reasonable for us to go live this time because the video would break. We would not be able to communicate properly with even the 100 people that we are talking to right now. So there's no point of. So yeah, you can communicate that to your friends, and I think we are already here at our limit, almost 96 people. So I think Bakula, you can start with the workshop.
Thank you, Nidani. Good afternoon, everyone. I'm Bakula, Executive Member of the Moot Court Society, and I'll be conducting the first workshop in a series of workshops that we are planning to conduct that will be dedicated to the FI, Freshers Induction Mode. Now, before we begin with what this workshop is going to be about, we'll discuss what are moods. So before we begin, I want a show of hands to see how many of you attended the demonstration on the orientation. Great. I see a lot of hands going up. Good to know. How many of you volunteered for KK Luthra? Yeah, yeah, I see a lot of hands going up. So one of the lucky things that happened with your batch is that KKL happened before uh, FIM, so you all had some exposure to know, how things happen, especially those in specific departments. Some of you got to observe the courtroom proceedings, and some of you got access to the memorials. So you have some vague idea. But for the benefit of everyone present here, we will first address what are moots. So moots are basically courtroom simulations in which the law students, get prepared to speak like a lawyer, to think like a lawyer before they graduate and actually become lawyers. So it involves three steps. First is you do the research, identify issues, and do the research. The second step is that you draft a memorial, which comprises of written submissions. And the third step is you present your arguments orally in front of the judge and make your case. Our workshops are also going to be along the same lines. The first workshop, that is today's workshop, will deal with two parts. One is how to approach a moot problem, and the second is how to do the legal research, which we'll be having today. The second workshop will be on how to draft a memorial, and the third and the final workshop, which will be 2 days before the FIM, would revolve around how to present your arguments and court mannerisms. So, what are the benefits of mooting, and why should you be doing mooting, and what are the skills that you gain? So, first of all, you learn to articulate your thoughts better, right? One of the basic skills of a lawyer is to be able to articulate your thought, communicate your thought, and persuade the judge. So, here you get to learn that. Second, you learn to do some intensive research. Now, as third year students, we already suffer limitation that the 5 year students do not have. So we have to learn it all quickly. So you work in a very high pressure environment and learn to do a lot of research and improve your communication skills within a short span of time. And third, you also get to network. So to be able to participate in the moot court competitions or to represent CLC in other competitions. So we will have competitions conducted by different law universities across the country. To be able to participate in these competitions, one of the preconditions is to become the member of the Moot Court Society, for which we are conducting the Freshers Induction Moot. One thing that is unique to this is that you're not going to compete against anybody as is the case when you actually start participating in the competitions. But here, you and the judge, you will represent, you'll take a side and you'll make your case. So it is encouraged that all of you give this a shot. So some of the ground rules before we begin with the workshop, all of you are requested to stay on mute. If you have any doubts or clarifications, feel free to post it on the chat box. One of our executive members would be looking at it and responding to it. And a heads up, we will not be dealing with any problem specific questions. So if you have any doubts pertaining to the jurisdiction or who is representing who, or anything of that sort, we will not be dealing with those questions. All the questions that we would be taking up will have to do with the process of mooting and how you go about it. And third, any doubt that you have with respect to the moot itself, you can fill the Google form. We have released a clarification form. You can post in your queries and we'll revert to that. And otherwise, you can also later on look at the recorded version, and then in case you get any doubts after 3 years, because 3 days, you have some time to prepare for the moot, you can post in your questions and we'll get back to you with the responses. Now, another one important aspect that I want to address here is, Neelangi, do you want to add something?
Yeah, I just wanted to add that I see a lot of hands raised here. In case you guys have any questions or doubts, don't worry. We will be having a proper Q&A session for after every part of the workshop is completed, and we will be addressing all your questions and doubts. We just request you to lower your hands. We will address all your questions and doubts in our Q&A session. Just addressing that. Yeah, Vakula, please continue.
Thank you, Nilangi. So one of the questions that a lot of people ask us is there a language barrier? Yes. No. Yes, you have to present your arguments in English and you have to make your written submissions in English, but language is not going to be a barrier. I'll share a personal experience. A lot of my batchmates who I've seen were very passionate about law, asked the right kind of questions in the class, but were hesitant to participate in the FIM because they thought they did not have excellent command over the English language. तो हम ये नहीं चाहते कि ऐसा हो. A lot of people do not worry about that. It is not, rest assured that this is not the only criteria, the preliminary criteria that is going to be on the basis of which you're going to be judged. It'll be one of the criteria, but what the judges would be more interested in looking at is your legal research, how thorough you are with your research and the kind of arguments that you're putting forward. So your grammar, your language is not going to play an important role. So we do not want that situation happening again wherein language becomes a barrier. So we hope that the 100 of you or even more number of students who are looking at the recording do give FIM a shot. Now, without any further ado, we will dive right into how to approach a moot proposition. So, I hope you all have read the proposition. Can I see a show of hands as to how many of you have gone through the proposition? Yeah, that's good to know. I see a lot of hands going up. We really appreciate that enthusiasm. We did not do that in our first year. So, the first thing that you can do to get yourself familiarized with the facts constitute the most important thing. It is on the basis of which you do your research. It is on the basis of which you make your written submissions. It is on the basis of which you present your oral arguments. So, facts are the most important when it comes to moot. And it's advised that you take a printout. Of course, you have it on your laptops, you have it on your iPads or whatever, and you can highlight it. But it's suggested that you take a printout of your proposition and go through it every day. Read it as many times as you can. It is not necessary. It is not sufficient to just read it one particular day and then let it be. You have to read it every day because every new day a new fact comes into light. In the sense that you might have read it, but you may not have thought of it as relevant. Again, I see a lot of hands going up. If you have any doubts, post it on the chat box, but make sure that you lower your hand so that we don't uh, get interrupted. So once you take a printout, highlight the facts, take as many notes as you can to understand. Ask the right questions in the facts because they play a very important role. When even a very simple line like this is a country with progressive country or with secular values, all of these lines can also be used in your arguments. You'll never know when these facts will come to your aid. Only when you're presenting your arguments and the judge puts forward a question, immediately that will occur to you. But for this, you have to have these facts in your fingertips. So make sure that you read and you familiarize yourself with the facts as much as you can. The next step is to identify the relevant section. Now you have read the proposition, you know what is happening, who is there, and what is the problem. You have a broader understanding of the problem. You now identify the law applicable to it. If it's a murder, if it's theft, then IPC is applicable. If it is a case of negligence or defamation, then torts. So you have to identify, that's not a law, but it's an uncodified law, but you have to identify the law or the laws applicable to the problem. The next step would be to identify the relevant sections that are applicable. So this you will get to understand while you all have given your entrance. So this is not a very difficult problem either. So you'll be able to understand the.
Sorry, Vakula. Whoever is doing this, whoever is sharing their screen, please stop that. This is not appreciated. We will kick you out of the meeting. Yeah. Please continue, Vakula.
Yeah, yeah. Thank you, Nilangi. So you have to identify the section. Once you have done that, then you have to pick up commentaries and Bairacts. First, open the Bairact, then look at the section. If it's section 15, what is that section talking about? You have to break it down. Once you have that, there are in the Bairact itself, there is one paragraph in which you read the commentaries. Otherwise, just do a Google search and find out what the section is talking about and have a basic layman understanding of the section. Now that you've understood the section, break it down and then you have to apply. These are the legal principles. Find the essential ingredients, and you apply these legal principles to the fact that you have in case. For example, let's take the case of defamation. I hope you're all aware of what defamation is. So now you have identified the section, and now you have certain essential ingredients. It's let's say the first ingredient is that the statement must be made against the plaintiff. So you have to identify who is the plaintiff here. Was the statement actually made against us? So these are the facts that are there. The so this is how you apply the principles to the facts and identify how you're going to present your arguments. So far, if you have any doubts or anything, you can post your questions again on the chat box. The fourth step, or the most important step, is to frame an issue. How do you come up with the issue? So here there are two questions. There are questions of fact and there are questions of law. So question of fact is a question that must be answered by reference to the facts themselves, या फिर evidence, या फिर circumstances के basis पे. जैसे defamation, in the case of defamation, you go through the facts. Was the you know article published or not? Did the third party get to know about it or not? Was the plaintiff actually the reputation suffer or not? These are all questions of fact. These are not the questions that you will frame in your written arguments. What you will be interested is the legal questions. So in the legal questions, you will have questions like, will so and so be liable for defamation? As defamation happens. So these are the legal issues on the basis of which you will make your written submission. So the fourth and the final step would be identification of the legal issues. Now it is up to you. You have read the proposition. You will get to know what are all the legal points involved, and you have to frame questions. But it is advised that you frame 2 or 3 issues only, because you won't get a lot of time to in your oral arguments. So be thorough with that one issue that you're dealing with. So just to quickly summarize everything that we have seen so far, first you read the problem, get familiarized with the problem, read it as many number of times, and be thorough with the facts, have them in your fingertips. Second is you identify the law applicable. And third is you identify the relevant sections and have a broader understanding of the section. How do you form this broader understanding? Pick up your direct, pick up commentaries. Commentaries are basically books. For IPC, we have PSA Pillai. For torch, we have RK Bhangia. So pick up these books. These will give you some information. They'll break down the section for you. They'll give you examples. So you get that idea. And then you see how these points are applicable, legal principles are applicable to the facts of the present case. And the last step would be to frame these legal issues. Before that, you'll have to pick up your side. Your issues will be framed on the basis of the side that you pick. So there are two sides, right? You either are the plaintiff or the defendant. So read the problem thoroughly before you pick the sides, because you cannot change the side once you have filled the form. So after you've chosen the side, frame the issues accordingly. So these are all the aspects that I wanted to cover in this first part of the workshop. If you have any questions, feel free to ask them. I see Antim Kumari Singh, if I'm pronouncing your name right. Do you have any questions?
Hello, can you hear me?
Yeah. Hi. Yes.
Sorry for the background disturbance. Actually, I'm in a metro. I just want to know about the framing of the case. Actually, I'm a little bit confused about this. So, can you just repeat for me, like how we just frame this in a format? Like we just research about the case, research about the about the summaries and the sections, illustrations, but like how we just frame this in a one format. I'm a little bit confused about this.
Yeah, Deelangi, do you want to respond to that question?
Yeah, I'm saying that do not worry about that, because right now Vakala has just covered how to approach a mood problem, what all is relevant for approaching a mood problem and framing the issues. How to do research will be covered in the second part of the workshop. So we will be covering all of those points that you are raising, Antim. We'll be covering how to do research, what all sources are there, how to find the summary or illustrations which are relevant to you. All of that will be covered in the second part of the workshop.
Thank you, Nilagiri. I also see Ratnesh has asked how to find precedents. Yeah, this is something that will be covered by Nilangini on how to make a legal research. You'll know how to find the right precedents for your case. Rishi Raj, how to make memorial. Yes, we'll have our second workshop dedicated to drafting a memorial. So do not worry about it. At this stage, all you need to be concerned is how to get familiarized with the facts, like how much you know the facts. Anytime someone asks you a question, you must be able to put yourself in the shoes of the person and then, make your argument. So it is important for you to have those facts in your fingertips. That is what is important at this stage. So we have a separate workshop dedicated to drafting a memorial and presenting your oral arguments. लेकिन अभी उसकी फिक्र करने की जरूरत नहीं है. So this is what you need to look at. And also while reading the facts, first step is you reading. Then you read between the lines of the facts and you're allowed to make some reasonable inferences कि यही हुआ है. So for example, if you see a fact like she was pounding on the table and screaming, so the reasonable inference is this person is angry, right? So only when you start reading between the lines will you be able to make reasonable inferences. Please note कि you cannot make assumptions. कुछ भी नहीं कर सकते. तो ये what is this moot compromise or moot proposition is basically a statement of facts that has been a bunch of facts that has been given to you by your client. How is the difference if, for example, in a real life scenario, you're a counsel, your client comes and says, कि ये हुआ था, for example, I loaned this amount, 50 lakhs to someone, and they said they'll repay it to me in 10 days, but they have not repaid. I asked them again. See, these are all facts that you count. They are not going to come and tell you there is a breach of contract or anything. They're just going to give you a statement of facts. This is what moot compromise basically is. It's a bunch of facts. But here, what is different in moot compromise is that these are facts that both the parties have agreed to. So you are safe to say whatever is there, you can make your arguments on the basis of that. So that is what these moot are all about. The proposition is all about. Is there any other question?
Yeah, there is one question. Will there be cross questioning or just one way presentation? So, in this particular case, usually what happens is even in a traditional mood, there is no cross questioning directly per se with the other participants. It's only with the judges, and even that is not per se cross questioning because judges are the one which who are questioning you or grilling you on the basis of the memorial or the oral argument that you are presenting. So, that same thing will be happening in this FIM as well. So you will be questioned upon your memorial submissions and your oral arguments by the judges. You cannot ask them questions, you'll have to answer them. But yeah, that is how the format will be. And all of that will be covered in our third workshop of oral advocacy and mannerism. So you do not need to worry about that.
Okay, just to add to what Neelangini has said, one of the advantages here is that you're not competing against anybody. So you can sit with your friends and discuss the facts. Sometimes what happens, if you had seen the demonstration, there were two parties, right? Tanishka and Aditya. Now, when you're reading the proposition, maybe you're blindsided because you strongly feel towards one of the parties. You've already chosen your client key, this is who is going to be the client, and you become often oblivious to what kind of arguments might come from the other side. So it is important to have discussions with your friends ki what if they have chosen the other side, make sure that you have these discussions because you're not competing against each other. You and the judge are the only people who are going to be there and having the conversation. So you feel free to have these discussions so that you get to know what kind of questions can come from the judges. You can in a way foresee the kind of questions that can come from the judges because if you're representing the plaintiff, the questions that the judges will ask will be from the defendant's point of view. So make sure that you have these conversations with your friends. So any other questions? um
How much time do we have to we get to present our case, like time duration for the oral argument? So it is already defined in the rule book that is attached with your compromise, and it is 15 minutes that you will get to present your arguments in total. So yeah, guys, just in case you have doubts regarding what is the marking criteria or on what basis are we being judged, what basis our memorial is being judged, all of that is covered in the rule book. Very detailed analysis has been given ki marks criteria kya hoga, 15 marks for what, 10 marks for what. So you can refer to your rule book once, like that will clear out a lot of issues that you might have. So yeah.
And ये भी
Any other
होता है
question?
just to deal with the practical things. There might be some people who want to be perfectionist कि ये aspect नहीं cover हो रहा है, and they give up at the last instance. I mean, I've seen some friends who are really good, but the day before the submission of the memorial, they give up because they think that they've not covered every aspect. Here, the objective is to qualify and become a part of the Moot Court Society so that you can represent your college in different competitions. So, वो perfection को मत आने देना. Even if you've not covered something, even if it's incomplete, just do it and give it a shot because it will improve your confidence, right? So, this is the first step that we are taking. So, do not let all of these factors come into play or affect you. So be confident with what you're doing and be thorough with your preparation, be thorough with your legal research. We'll guide you in these workshops as to how to go about the research, how to draft your memorial and everything. And you are feel free to reach out to us. Yukti, can you post the mail address? Is Yukti here?
Yeah,
On the
Yukti
group.
is here.
Go through the schedule, be present for all the workshops. And also, there is this mail ID. You can post any of your questions that you have regarding the process of the moot on the mail ID, and we'll revert to it. So you can feel free to reach out to us any case. During the course of your preparation, if you have any doubts, you can feel free to reach out to us at any point of time. Antim, do you have any question?
Okay. Adding to that, just remember one more thing. Yeah, so see, it is very clearly mentioned that the mode of competition or the language of competition for FIM induction is going to be English. So you cannot answer to the judges in Hindi. But you have to remember that just merely because you have to participate in English does not mean that you are completely being judged on the basis of your skill to be able to speak. Okay, it's not just that. Like your language is not the only thing on basis of which you're being judged. So that's what we were trying to say. And just remember, as you can see in the rule, there are cutoff marks which are already specified. So we don't have any cap as to how many people we take from FIM induction mode. Anybody who crosses that cutoff mark criteria is going to be part irrespective of the number of people. If 100 people cross that, 100 people are going to join the moot court society as FIM inductees. So yeah, that is also there. So and another question that we have is, when will second workshop be held? We'll soon release the notice for second workshop. And how many students get selected for the society? I've already addressed that we do not have a cap. As many students as they can clear the cutoff criteria. So Yukti has already added all the notices and all the relevant documents, so you guys can refer to that. And now I think if nobody else has any more questions, then we can uh, move on to the second part of the workshop. Just one more thing I can see, how should we prepare for the upcoming induction process? So we are kind of having the workshop for the same purpose, Kanupriya. So yeah, we are trying to help you right now to understand how to approach the mood problem and how to do the research. Then in the next workshop, we'll be covering uh, how to make the memorial, and after that we'll be covering how to do the oral advocacy and mannerism for the courtroom. So yeah. Okay.
And as far as volunteership is concerned, that is for second year students. Like those who are participating will not get to volunteer. Just like in KK Luthra, we had different departments. You can volunteer for FIM if you choose not to participate in FIM, but as first year students, it is encouraged that you all give FIM a shot and try and become a member of the Moot Court Society because the learning opportunities are abundant. So that is it. If you have any more questions, feel free to ask. If not, I'll hand it over to Neelangini. But all the very best. Keep reading the facts. When you're walking, when you're sleeping, think about the facts and give your best. All the very best. Now over to Neelangini if you don't have any more questions.
The cutoff criteria is already mentioned in the rule book. You can refer to that. I think it is 15 marks for memorial and 45 for the oral rounds, if I'm not wrong. You can refer to the rule book though. Okay, think we can move on to the research part. Regarding the volunteership, so yeah, though Vakula has mentioned that second year students preferably should be volunteering for this. In case you're not very sure and you think that this is not the right time for you to do FIM, or you for some reason are not able to do it, then you can volunteer for the FIM to understand the process better, just in case you are not feeling like you are ready right now. So yeah, that is one way to go about it, that you can, at least familiarize yourself with the process in case you did not volunteer in KKL, or you did volunteer in KKL and you like that work more. So yeah, that is up to you. And now we'll move on to the.
Anil, just a second. So there is also common induction mode. If in case you miss the bus here, and if you're not able to submit your submissions on time, there is also common induction mode, which is open to all the 3 years. So you will then be able to still avail the opportunity to become a member of the Moot Court Society. So you can choose to volunteer as a first year student in FIM and get into the society. We had some really good people coming into the society through CIM. So that is yet another way through which you get inducted into the Moot Court Society. But we wish to see all of you there. Yes, Nilangi, that's it from my side. You can take over now.
Okay, guys, so now we move on to the research part. So, a lot of you now have a clarity on the idea as to how to approach a mood problem and how to frame the issues, right? Now, you start with your researching. So, I'll start with the research of statement of jurisdiction. So, first of all, we are not going to tell you exactly how to do that, but the idea of statement of jurisdiction is, first of all, you have to determine what sort of case it is that you're dealing. It can be a criminal case, a civil case. जैसा आपका केस होता है उसके हिसाब से आप डिटरमाइन करते हो किस तरह के कोर्ट्स में वो जाएगा. आई एम श्योर ऑल ऑफ यू आर स्टडिंग jurisprudence in first semester, so you already have hierarchy of courts and jurisdiction there also. So you have to determine the nature of case first, then you have to determine the relevant factors. I'm sure you guys have already read about things which determine or are relevant for determining jurisdiction. Okay, there is pecuniary, territorial, a lot of different sort of things which you have to take into account while determining the jurisdiction. And then you have to take other factors into consideration on the basis of which you can determine what sort of jurisdiction is your particular case falling into. Okay, and then you determine the statement of jurisdiction. So you have to do the research for it on your own, and you'll figure out a lot of things, you'll learn a lot of things. You can refer to a lot of statutes. There is CPC, CRPC, a lot of them have different uh, relevant clauses regarding the jurisdiction. So you can go through them and figure out what the jurisdiction is going to be. Just pardon me in case I get a little lost here, because I'm getting a lot of requests from people to join the meeting, and since we are already full, it's hard for me to add them. So yeah. So now, as Vakula has already, that you need to after reading your mood proposition multiple times, you figure out what the issues are. Okay, now what your research essentially has to do is you have to figure out how those issues have been addressed by the courts in different factual situations by applying the law that you think is probably relevant as per your assumption. Okay, so that is what your research is all about. What you essentially have to do is your primary research is done once you have identified the statute, you have gone through the Bare Act, you have gone through the commentaries and understood what the law exactly is applicable here. Now, when you go through the commentaries, what you'll see is you'll see a lot of cases which are mentioned there. So a lot of landmark cases or cases which are very having supreme authority on that particular aspect of law or concept of law is present there in the commentary itself. You can refer to that. That can be your starting point to get to know कि यहाँ से case laws हमें मिलने start होंगे. उसके बाद से one more thing that you need to keep in mind is hierarchy of courts. So I'm sure that you all are already aware, since you gave the law entrances and everything, what hierarchy of courts is. That Supreme Court is there. So Supreme Court's decision are binding on all the courts, and since most of your moot propositions have this, that whatever country that you're dealing with is paramateria with India, and whatever state you're dealing with is paramateria with some state of India. So you can figure out that all the Supreme Court judgments are going to be applicable and binding on the particular judgment, sorry, the bench that you're arguing against. And now one more thing that you have to keep in mind is, even in Supreme Court there are 5 judge bench, lower like less number of judges in a single bench or whatever. So you have to keep in mind कि किसका judgment किसके ऊपर precede करेगा. So you need to be very clear with the hierarchy of courts. Same goes with high courts as well. In high courts, like in a particular local area high court, uh, जो हाई कोर्ट की jurisdiction होती है वो टेरिटोरियल होती है in the local limits of that particular state. So for instance, Delhi High Court is only going to be like the decision of Delhi High Court is going to be binding on all the territorial district courts which come under the Delhi High Court, but it will have a persuasive value in case of your argument being argued in some other high court. Okay, so it'll have a persuasive value, but you need to be clear about what the hierarchy of courts is. Now it comes down to as to how to do the research. So say for instance, now say you're dealing with a concept of negligence. Okay, so now you know negligence में हमारे पास आप जाओगे negligence के बारे में पढ़ोगे. It's a taught concept. It's in your syllabus. You go to R.K. Bhangia or you read about it. You see versus Stevenson is a leading authority on the negligence. So now you start looking for Donahue versus Stevenson. Donahue versus Stevenson must be cited in a lot of cases. So you go through those cases. Now how does this process works? How do you find a relevant case? Okay, so यहाँ पे समझने के लिए सबसे जरूरी हो जाता है that you need to be very clear with your facts. Now you have clear with your issues. So best case is going to be something which is addressing that particular issue along with having certain similarities with the facts that you have. Okay, what is the number of facts that you can deal with, or sorry, what is the number of cases that you can deal with, how many number of cases should you cite? That is a very separate issue as long as your case is relevant. It does not matter the number of cases that you are citing. Okay, if suppose somebody is citing 40 cases and somebody is citing 8 cases, but the 8 cases are very relevant as to the argument that you're presenting, it's substantiating your argument, then those 8 cases would be sufficient. It's not required that you have to go and have a long list of cases present in front of you. In fact, one thing that you can keep in mind is that whatever number of cases that you present in your memorial in the authority list, the judges can ask you a question about it. So you need to be thorough with the cases that you're referring in your memorial as well, that what is the ratio of that case, what are the basic facts of that case, and what was the issue raised in that case. Okay, so these aspects are very, very important. uh, no, as I already addressed that more number of cases does not mean a better memorial or a better argument. It's simply which is the most relevant case. For instance, usually if you go through your research, you'll realize that you know one or two cases are usually the supreme authority on a particular concept. In those 2-3 cases, the main gist of that particular concept was laid down. Okay, for instance, negligence has been laid down in Jacob Matthews case or Donahue versus Stevenson. Very in detail, they have laid down the concept of negligence and they've discussed it. But you know, Bhagla, you have something to say.
No, just to add, once you're done, I'll just add to it.
So they have already laid down the basic concept there. Now you'll see that rest of the cases of negligence merely have the citings of those judgments. That in Jacob Matthews, this was held on basis of that they are making their pleadings. So once you go through a case, no, whatever case that you're referring to, let me get into that the structure of the case. So you know, the more you read the cases, you'll understand that there is a structure as to a judgment that comes out. Okay, initially it starts with the basic facts of the case. Okay, first few paragraphs or maybe 1 or 2 paragraphs are dedicated to the facts of the case. Later on, you understand what the dispute is about, and then you go to the issue, that this is the issue of that case. And then later on, you see the contentions of the party, that one party is contending this, and the other party is contending this. And then it comes down to the judge and his interpretation. Then he takes into account all the contentions, and then he takes into account all the things that have been argued, and he lays down a ratio which is relevant. Okay, which is the most important part of the judgment, on basis of which he forms his decision, that this is the established point of law on basis of which we are establishing this decision. So this is a structure that you'll find once you start reading a lot of cases. And see, we are in the profession of law, so reading cases is going to be a very, very daily part of your life. Okay? It's like there are 50 cases in each of the case maths and 5 case maths every semester, so you can just guess the number of cases that you have to read. So the more you read, the more you'll understand the structure is there. Now, Vakula, you wanted to add something, so you can add it, then I'll move forward.
Yeah, so there are two kinds of judgments. One are the landmark judgments, right? These judgments have laid down principles that hold true, that might have been given in 1976, 50, whatever it is, that hold true even today. Then there are judgments that suit your position. So if you have taken the plaintiff, you might find that you have to see if whether the facts of these cases are similar to a particular case. It may so happen that the facts exactly match another judgment, and the judge had given a judgment in favor of the plaintiff in that case. This makes your case stronger because the facts were similar and the judge had ruled in your favor. So these are the kind of precedents that you should be relying on. So the judgment, as Neelangini pointed out, comprises of two elements, right? The ratio and the obiter dicta. Make sure to find ratio, that is the decision that supports your case, because the obiter dicta, the observations, they have persuasive value. Of course, to substantiate कि हाँ यही है, ये principle है या ये discuss हुआ था, this will have a persuasive value when you're making your oral arguments. But what becomes more relevant is the the ratio of the case. So you have to find a balance between the landmark judgments that have laid down the precedent, as well as these judgments that support your claim as a plaintiff or as the defendant. And also, yeah, that would be it. So there are someone is asking, there are so many judgments running into so many pages. So first start with the commentaries. Okay, they'll contain just the relevant part. There might be multiple issues that are being dealt with in a judgment, not necessarily contract. You might have contract, you might have IPC, all of it in one judgment. It involves different statutes, but what you're interested in is just this contract portion of it, or let's say the IPC portion of it. So make sure that you use a control F or go to just that issue that you're interested in. You don't have to read the entire judgment or waste your time. You just have to identify that relevant portion of the judgment that is necessary to make your argument. So that would be it to answer Ashwani Kumar Singh. And Neelamni, you can take it.
So as Vakula has already cleared up, okay, and there is also timeline. So as we said, there is landmark judgment, then there is a some other judgment which has just substantiated the landmark judgment. Now, what you can do best is, landmark judgment will have the principles laid down. But if you can possibly find a recent judgment, a relevant judgment where that landmark judgment is cited, and which has a fact similar to your particular case, or anything like even the issue similar to your particular case, if you can cite that, that is a good way to go about it, because there are certain judgments which have, like, they are privy council ke time ki judgments. Okay, 1924, 1920s, वहाँ पे privy council has laid down the concepts, and even now we are using them as landmark authorities on that particular concept of law. So what you can do is try to find judgments which are there. And now, coming down to how to find these judgments, where to look for these, and you are asking that there is a long case, so how do you find that relevant aspect? So once, just give me one idea that whether you guys have received your institutional IDs and whether you have access to due e-library or not. Like, show a raise of hands कि किस किस के पास institutional IDs हैं कि नहीं, तुम्हारे बैच को मिली हैं कि नहीं.
All we don't have.
First year batch does not have. Okay, sad, but all right. Okay, not yet. Okay, so you guys are going to have a little bit of issue SSC nahi, but it's all right. So see, what is the alternative? So what happens is, there is Indian Kanun, the sources. Okay, essentially the sources to find your cases. So first of all, Bare Act and Statute is your most primary source. Then you go to these websites which have the case records. Okay, so there are a lot of citations that you must have read. Okay, that 1980 All India Reporter, this, ठीक है, this page number and this reference point from where, or SEC. So these are all reporters which essentially report the cases from Supreme Court, High Court, depending upon whatever courts that they are reporting. So what happens exactly is that SEC, Manupatra, these are databases which contain all of these cases, and you can refer to them whenever you require. So these are like the paid ones. Okay, Manupatra, SEC, both require either IP access, or they are paid individually if you want to use them. So usually what college does is they provide you with an institutional ID, and then you can access all of these through your institutional ID, and you can go through these databases. But since you guys have not got your institutional ID, there are other websites. So there is Indian Kanun, first of all, which is most famous and most out there, open source database of cases. Okay, but when you are referring from Indian Kanun, what becomes a little bit difficult is that you have to do control find constantly, because they do not have head notes or anything. In SEC or any other like website database, you find a proper head note. So just, if you give me one moment, I'll open this one more website which I prefer, like best, in case आपके पास SEC, Manupatra कुछ भी नहीं है, तो that is Case Mine. Okay, so I'll just share a tab, and yeah, so this is Case Mine, guys. So you can log in. What you can do is, you don't need your like, you just need to log in from your email address or institutional ID. If you don't have one, just log in from your email address. What they'll ask is, they'll ask you for a ID card, college ID card, and then you can just get into this. And this is also just as good as like case my sorry SEC or Manupatra. What you can do is you just refer to any of the cases here. Okay, like
Well, can you share the link?
yeah, definitely we'll share the link. Just give me a moment. Okay, so see, for instance, here I was searching for some case, and here they have important paragraphs. So, what Case Mind does is it also gives you important paragraphs, it gives you summary, it gives you here citation codes. Okay, so citation codes are here, you can cite the relevant citation. You have to check, guys, do not ever like just cite a wrong citation, don't do that. Okay, so, okay, this you guys are not even telling me this was not visible. Is this visible now? Hmm.
Cool. So
Yeah, so
all
I
the
was
questions with regard to formatting and everything will be dealt with in the memorial, so you don't have to worry about it. We are just dealing with research. So yeah,
okay.
that is something that I
Yeah,
can.
so sorry. You guys can correct me in case the right tab is not sharing. Please do that. Otherwise, I'll keep on speaking because the screen is not visible. So yeah.
Now it's visible. Now it's visible.
Yeah, so you can see. So now I was reading this case. This is a Supreme Court of India case. Important paragraphs are already marked here. Summary of the judgment from whatever their AI has depicted is available here. And all the cases or all these laws that they are referring to, okay, like Delhi Rent Control Act is here. Section 106 of Transfer of Property Act is here. Okay, so all of these acts which are used, the judges which are advocating, so you get a head note sort of, the point of sharing Case Mind with you guys or showing Case Mind to you guys is that you get an idea that there is another website. You can submit your college ID card, they approve you and give you free access to it for at least a year. And after that you can just go through Case Mind, you can search all your cases, you get important paragraphs marked. But just remember, just because important paragraphs are marked somewhere or you're going through something, do not miss out on the entire judgment itself, because you need to know entire thing. Of course you need to do smart work, but at the same time you can't just run away from the hard work either. So what you can do is, see, you got the idea of the landmark case. Now landmark cases are usually very long. Say for instance, if you're dealing with an issue related to privacy and you're going through Puttaswamy judgment, it is 700 plus pages. So obviously you're not going to read that, but you have to go through the relevant paragraphs of that judgment. So once you find out a summary or some commentary online or some blog where the judgment or summary is given, then you can refer to those particular paragraphs in the judgment itself, go and read where that is and what is that referring to and everything. So you have to do that, especially like develop this habit from the very beginning. Otherwise you'll start cutting off on this whole thing, and that would not be great in the long run for you guys. So yeah, so now I hope it is clear that you can go to Case Mine or you can go to Indian Kanun to refer to your cases. How do you find these cases? Commentaries में से landmark judgments तुमको मिल गई, then you have to find which judgments suit your case best, ठीक है? And what you do is you see where are these judgments cited. So in Case Mine also, and I think in Indian Kanun also, you will get a lot of citations. While you read the judgment, you see a lot of judgments are being cited. Once you go to those cited judgments and you see what are the issues discussed there, then you'll get an idea कि कैसे कैसे कितनी सारी judgments तुमको मिलती जाएंगी. You'll see there will be a flow automatically created कि यहाँ से start किया था, यहाँ पे ये वाला issue determine हुआ है. In this judgment, the judges refer to this judgment to determine this particular issue. So you go to that particular judgment, you'll realize this is also relevant to your case. So you can add it to your entire list of cases that you're referring to. So that is how you go from one case to another, and that is how you find cases which are relevant to the concept of law that you're dealing with. Because once you find, that is why we are constantly saying that if you go through the commentaries and you look into the landmark cases, you see where these cases are cited, you'll get the idea as to how to make a flow and how to find more relevant cases on that particular concept of law. So you start from here, and then when you deep dive into the research work, you'll find it. Now one more thing that I'd like to suggest is that limit your time to a particular issue or a particular concept that you're like searching. Okay, so searching in itself is another ball game altogether. Okay, just because you're clear with the law, just because you're clear with the proposition, doesn't mean that you will be able to just go and google it. You can't do that. So you have to be very mindful of the keywords that you're using. Say for instance, you are dealing with some issue regarding to theft, so now you know what section that you need to search for, or what proposition in that particular section that you need to go for. Okay, so you have to be very clear that in case after a half an hour limit or 1 hour limit you have decided that this is the proposition that you need to search, if you're not able to find something, then reconsider the entire thing. Am I using the right keywords? Am I using the right proposition to search? Because otherwise it can be very daunting, and it can be very demotivating if you start and you stuck yourself 2 hours on a particular proposition and you're not able to find anything which is relevant to the argument that you were hoping to substantiate. Okay, so that is one thing. Now how do you do this research is, you've since you've identified the issues, you clearly have certain arguments in mind, right? That whether negligence was there or not. So there are three essentials of negligence. Okay, there must be a duty, there must be a breach of that duty, and a damage must be caused. There are three requirements that you need to fill. So now you can show that these are the propositions on basis of which negligence is proved. Now you utilize the facts, that a fact is given to you ki somebody went to a shop and they were served something which was not proper for serving, or not fit for serving the other person. So Donahue versus Stevenson ki pure facts jo hain, that are directly applicable here. So you see that here the person had a duty to serve a proper food item to the other person. They breached that duty, and now a damage is being caused, that the other person is hurt by this particular eating this uh, bad food. Okay, so you get the idea that you are utilizing that concept of law of negligence, then you are utilizing the facts, and you are combining that to formulate an argument. And that is what you're going to do with your research also. You find a case law, you find the principles, then you'll find how those principles are applicable to your set of facts which are given in the Moot compromise, and then you formulate your entire arguments, right? So when we cover the workshop for how to draft a memorial, and we cover the aspects of summary arguments and arguments advance, this will become more clear as to how you have to utilize your research. One more advice that I'd like to give you regarding research is that make sure that you are noting down everything, and you're writing this at least the source of that research, so you can constantly go back to it. Because what happens is, you go through so many cases, you go through so many propositions, and there are too many propositions. You'll realize there are at least 2 to 3 issues in whatever mood you ever go to. Like at least 2 issues are minimum that you have, and then there are sub issues within those issues. Okay, so you have to be very clear that this particular research was related to this particular sub issue, and this is the source of it, this is the summary of it. If you are going through a very long judgment, it's very 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 important that you briefly summarize it in 2 to 3 like lines as to how this particular judgment is relevant to your case. Otherwise it will become again overwhelming when you go back to that long judgment again. So keep summarizing and keep drafting somewhere on a Google sheet, on a notes, whatever app that you use. If you like to use pen and paper, then good for you, then pen and paper. Like keep noting that this is where this comes from and this is where this goes, so that you do not get confused in the longer run when you're dealing with the entire research and coming back to it while formulating your summary arguments or arguments advance. Now coming down to the sources that you list down. So what are relevant sources? So primary sources, yeah, Vakula, can you just continue after I complete this? Yeah. So primary sources may, it will definitely be like if you go through a sample memorial that is already uploaded on our Facebook site. So you can see that there is a index of authorities. So there are statutes and bare acts which are there. Then there are case laws. Then there are other commentaries or books which you can refer to. So these are usually considered the fair sources. Then sometimes when you're dealing with international laws or something like that, so there are certain agreements or treaties that you have to refer to, or there are certain online material that you refer to, a particular UN charter or something like that comes up. So you can also mention that in the index of authority. So these all are relevant sources as long as they are authentic and they're from the original site. Like for instance, Bear Acts and everything, you do not have to refer some law, like you are law students, so I'm guessing this is very unnecessary for me to explain that how much it is important that the source of the law that you're quoting has to be very authentic. Okay, it either comes from the government website or the Bear Act itself. You can't just quote anything. Okay, like you are going through a lot of blogs. You're gonna go through a lot of blogs. You're gonna go through iPleader. You're gonna go through Mondak. A lot of sources are out there, blogs which simplify the concept of law itself. So go through it. Be smart. Understand the concept better through those blogs, but do not refer to them while you're making your memorial, or while you're quoting something in your memorial or in your oral arguments. You can use those sources, those blogs, those research papers. I'm a huge fan of research papers because you get a very holistic view of that concept of law once you read a research paper about it. You get the pros, the cons, the arguments from the defense side, the arguments from the appellant side, or anything, and you get a very holistic view. But you do not like cite that research paper in your memorial. You go through the point of law, you find that case on basis of which that research paper is written. You will get a good idea of cases also if you go through a research paper. So yeah, that is like what you can do. If you go to Mondat, iPleader also, the legal blogs always contain the cases which they have based the entire article on. So you can refer to that as well. Now I think more or less the how to do the research part is complete. And in case you have any questions, you can start dropping them in the chat box and we can address that. Bakula, you had to say something. Please do that.
Yeah, so while you're going through these blogs, you cannot express your opinions. Make sure that you don't mention, I believe. You cannot have such statements in your oral arguments or your research because it cannot contain opinions. Every single line that you're uh, uttering has to be substantiated. So that is why you have certain sources that you rely on to make your arguments and certain sources that you rely on to get a broader understanding of the concept. For your understanding, you can verify anything. You can verify statements of opinion, whatever you want, but you can cite only these reliable sources that Neelangini has pointed out. That is one thing that I wanted to mention. And also adding to the keeping a track of the research that you have done, you should also, for every precedent that you have read, you should also mention the facts in 2 lines, because it so happens that sometimes the judges ask, because when you're actually relying on a particular precedent, they might ask, how is that relevant to this case? And what are the facts of that case? So then you cannot be blank, because often it so happens that in the principle they are discussing everything that is favoring the plaintiff, and the decision would be in favor of the defendant. So it is the fact that distinguishes and makes the whole difference. So the judges might be interested in the facts. So if you have cited 8 judgments, 10 judgments, 15 judgments, whatever the number of judgments, just mention the facts in brief, so that when the judge puts forward that question, you have. And it is suggested that you do it at this point of your research, because before the day of your like oral arguments, if you go and search for every fact, that's not going to be feasible. So as and when you're looking up a judgment, make sure that you summarize the facts as well in 2 lines, because this question can be asked, because often they are distinguished on the basis of facts only. The cases are distinguished on the basis of facts. So this was one thing that I wanted to add. The floor is now open for questions.
Yeah. So I think guys, you can start asking questions if you have any. Uh, and we can start answering them. I don't see any questions in the chat box as of now. News articles to justify our arguments. Yeah, so as Vakula already said, that you should not be citing these, to substantiate your argument, because at the end of the day, go to the source of the news article. It is essentially an opinion. Okay, unless it's a very, very, very factual news article or a research piece based on data analysis and everything, it's essentially an opinion, right? So you can't mention opinion. You can the only opinions which you can mention at are opinions of a judge, which is given in a judgment, not even outside a judgment. Even the opinion of a judge won't be relevant. A opinion of a judge in a judgment, that is the only thing which is relevant. In fact, when you're writing your arguments and you're doing the research, so what you essentially do is you substantiate your logic by or concept of law, the principle that you're following, on the basis of precedents of the judgments that you're referring, and then you apply that to the fact. The application itself is not opinion. That is like very direct, that this is the principle, you are applying it directly on the fact. That is not an opinion. So yeah, that is there. Now can we add those summarized facts in memorial, or we okay. So there is a concept of compendium which I think is supposed to be discussed in the next workshop. But just to give you a brief idea as to what you're saying, so what you can do is, usually compendium is a document where you refer down or list down all the cases that you've cited in your memorial, and you list down the important paragraphs Okay, so you can briefly lay down the facts and the important paragraphs of that particular judgment. And what you can do is you can give that compendium to the judges once you enter the courtroom, and you can request them to refer to this particular page number on the compendium where the relevant paragraph is. So that is something which is permissible, but otherwise, like for your own understanding, you need to note down the facts of the cases while you're researching so that you remember it. You need to understand that on what basis this facts is. And one more thing adding to this point would be that, there is, after the ratio, there is one paragraph in all the judgments where the judge is applying that particular principle that he has laid down to the facts of the cases. I personally feel that that is a relevant paragraph for you guys, since you guys are just starting on, to see how that particular principle laid down is being applied on the facts of the cases. So you get a better understanding as to how to utilize all the precedents that you are reading, all the case laws that you are reading, apply that to the facts of your moot compromise. Okay, so you can do that, like go through that paragraph as well. Right, like right now you guys have ample amount of time before submitting your memorial, so you have decent amount of time to do the research and draft the memorial. So I would strongly suggest that utilize this time to well versed yourself with the research, because this is something that you'll utilize in all aspects, like even if you're writing a research paper, or even if you're studying for your exam, okay, and you want to write a good answer, then you'll have to do it. So yeah, uh, any tips on how to write the facts of the cases, that should be covered in the next workshop itself. So yeah, you can wait for that. What is SEC? Okay, so since you guys don't have the access, so I don't know how good it is to show you, but I'll just give you an idea of what
Neelang,
is.
show them the website.
Yeah, I'll show them. I'll show them. So guys, is my screen visible?
Yes.
Okay, so don't tell me. Okay, okay guys, just give me a moment. Pagula, you can do this for that guy.
Yeah, in the meantime, to answer Ashwani's, no, Ananya's question. So, the facts of other precedents that you're relying on, it is necessary in case of the oral arguments. For example, if you have a line that says such and such is the sine qua non for this offense, right? And you are citing a precedent, you don't have to mention the facts of the case, because the that particular statement is the only relevant sentence that you're relying on. In which case, you do not have to get into the facts. But in case the judge asks you during the orals, you must be knowing the facts of the case. So write it for that purpose, but you don't have to mention the facts of each and every precedent that you're relying on in your memorial or anywhere else. You just have to have it somewhere so that when someone puts a question, you know where to refer to. So that is one thing, and it's not mandatory to submit the compendium. It is not necessary, at least for FIM, it is not necessary. And given the time constraints, it's okay to completely skip submitting a compendium.
Okay, so guys, now thanks Vakala. So now this is the DU e-library website. Okay, so what they do is they give us the institutional ID through which I have logged in here, and what you can do is you can go here, you can search for SEC online. Okay, as I said, it is a database. Now you go to the SEC online website. So I hope SEC online website is visible to everybody.
Yeah.
Okay. Now you log in, you do IP login here. Okay. So whatever roll number or institution ID that you have, you put that in, and you get in here, and this is your SEC online. It's essentially a database. Okay. So there are different ways to do research on SEC and Manupatra. A lot of videos are available on YouTube. You guys can refer to that, and you can just go search about any concept that you want. Okay. So say for instance, let's just do Kutaswamy judgment. Okay. So now you do that, and there are different types of things which you'll get the digest notes, you'll get the judgments, you will get legal or business articles, all of those things you'll get. Okay, now even the judgments are bifurcated as per the jurisdiction of the court. So this is, say for instance, the OG judgment, I think, yeah, 2017, 24th August. So now this is your SEC online. Okay, Uh, I have opened it थोड़े से larger view में. Yeah, so you can see there are index to head notes. Okay, so this is a very long judgment, guys. So you see here there are indexes. There is the head note, ठीक है, right to privacy, what all issues are being held here, what all cases have been referred while dealing with these issues. Okay, so these are all the head notes. You know, the head notes itself, because it's a very long judgment, are very long, but otherwise there are a lot of judgments where the head notes are small and you get the idea and gist of the entire judgment. But given that this is a 700-page long judgment, I think it's justified to have like a 2-page long head notes. So yeah. So this is SEC Online. Essentially, SEC Online is a database of cases, research articles, anything related to legal, you know, fraternity. They have moot problems, sample moot propositions, and sample moot memorials and everything. All of those things are there. And you guys should hopefully soon receive your institutional IDs and get access to that. So yeah.
Nilangini, can you also show them how to search, how to type a keyword and then get search results? Maybe negligence or something.
Sure.
Because they won't know the exact judgment that they need to look for, so they'll be looking up these words only.
Okay, so since we are sitting here, I'll also demonstrate how Manupatra works. Okay, so as you guys can see, you search Manupatra, you will get this. You click the tab, okay, and you click IP users. Click here. You go here, okay. Now this is Manupatra, guys. This is another something similar to SEC. People have their own preferences depending. Like you can try them all out. You can see which one is best for you. Okay. Now there is Manu search. There's legal search. A lot of things. If you have a keyword to search, say for instance negligence, or rather just negligence. Okay. You have to test negligence. You have to search. Okay. Now there are a lot of judgments here. These judgments are, this is the latest one, okay, key, the latest judgment that relates to negligence. Now you can here decide whether you want like Supreme Court of India judgments or what all judgments that you want, okay. And within this you can search in the result, okay, you can search in the result whatever you want, like test of negligence. uh, Sorry. Search. Hmm. Okay, so I don't think right now my SEC is functioning as I wanted to. Just give me 1 minute. So now you can see what I've done is essentially I've searched negligence here. You can see, and then I've refined the query and got through test for negligence. Okay, now once I select just the Supreme Court of India, all the Supreme Court of India judgment which are dealing with the test of negligence will come here. So when I open this, okay, yeah, this judgment is open now. So when I open this judgment, even here, there are acts and rules which are relevant to this particular case. And then all the cases which have been referred in this particular judgment are here. case category family law matter. So you already get this idea when you go through Manu Patra or SEC or anything like that. You get this idea that वो case किस category का case है, what all acts and rules have been referred to it. Okay, you get a basic sense that what you are getting into, so you would not waste a lot of time just in case it's not relevant to your particular judgment or particular area of research. Then you would not waste a lot of time on it. You'll see the head notes, you'll get the idea, and then you'll move forward because you know that this is not relevant to what the proposition that I'm searching. So yeah, that is there. Now anyone else has any question? Can be used anywhere or only in campus? Once you get the ID, then you can use it anywhere. I'm sitting in my home and using it. You can just this is remote IP login, so you can do it anywhere. But you need your institutional ID, which I do not know why they haven't given you, but yeah, you'll get it soon enough. Any more questions regarding the research part of, or how to approach the moot problem part of the like series? To bata do. We'll address all those questions right now.
And also, I've shared 2 links with you that has videos on how to use SCC or Manupatra. You can just go through that, and luckily, if you get your institutional IDs, you can get started with that. But in the meantime, you can refer to these commentaries and get started with your research. Like, do not wait for this, or you're not missing out on anything. At least for FIM, a lot of people did not use these websites excessively to submit their arguments. So you can rely on the commentaries and get started with your research without waiting for your institutional IDs.
Okay, so I'll address a few questions. First is, where can I find sample memorial? So we have already uploaded the memorial for the Moot demonstration Moot that you saw in the orientation. Along with that, there is a link of Law Octopus website where there are a lot of sample memorials which you can refer to. So yeah, that should address your question. Now the next question is, only Supreme Court cases are to be cited. That is a call that you have to make. Depending upon how you determine the jurisdiction, you have to determine what hierarchy of court is relevant here and which court judgment do you want to cite. This is not a question that we can possibly answer. So yeah, does this technique help in writing research paper as well? Which technique specifically are you asking, Isha? If you're asking about the research technique that we've discussed, then yeah, definitely it will help you out. If you have a very clear proposition in mind, I want to write a research paper on this particular proposition of law, then yeah, this should work well for like writing research paper as well. Please, it's helped me a lot while I was writing my research paper. Yeah. I think I've already addressed that the DO e-library facility is something that you can use remotely as well, as long as you have the institutional ID with you, which most of the first year people do not have. So that is not something which is like relevant to you guys. Can we cite English law cases as well? Okay, so this is one more thing which I would like to address. Great question. Thank you so much for asking. So, usually what we do is we confine ourselves to India only because, binding and persuasive value of the Indian judgments is higher, especially the Supreme Court judgments. But since our system of law is based on common law system, so it is always allowed to, go and cite English law judgments. In fact, if the law is relevant and the reasonability is relevant and you find that this is something that we can do, then you can refer to even foreign judgments which you find relevant to your pertaining to your particular case. For instance, while determining right to privacy, we have referred to US laws of privacy, Canada law of privacy, like a lot of different laws of privacy. The Supreme Court itself have referred to all those laws while determining our own law of privacy, right? So depending upon how relevant you find foreign judgments, you and how reasonably you can inculcate that in the memorial and your oral argument, you can definitely refer to them. But remember that they will definitely not have a binding value. They can just have a persuasive value in the memorial as well as the arguments. So yeah, that I hope is addressed.
Just to add to Nilangini's point, but as far as some laws are concerned, they're exactly adopted from the common law system, in which case you can rely on the landmark precedents because that is what is being followed. For example, you will find in which one? The some what is it? In company law, you might have all read, the landmark case of Solomon versus Solomon. It's an English law case, but it is followed till date to
First years, first years.
no, somehow. Okay, so there are some cases, is what I'm saying, and it depends on the law. For
Hmm.
some laws, yes, the English law, English precedents hold water even today, but otherwise, the recent judgments. If we talk about recent judgments in their relevance, they do not have like substantive value. They have only persuasive value.
Yeah.
And also to add to Ashwani's question, only Supreme Court cases. Yes, please give preference to the Supreme Court cases because a High Court ruling might have been overruled by the Supreme Court in a subsequent case. So we know that the Supreme Court's judgment are binding across every court. So try to find as many Supreme Court's cases as possible. But if you find a High Court case that is really compelling and it has not been overruled by the Supreme Court, you have to be very thorough because if the judges point out that it has been overruled, then your case becomes very weak. So you have to be very careful when you're citing the precedents set by High Courts. But so rely mostly on the Supreme Court cases.
Yeah, and adding to Vakula's point, just one more thing is that, like even in contract law or tort law, you can see there are a lot of landmark judgments and everything. So you can see how the old judgments are very relevant, but the new ones need to be properly, cited here. And now just sharing the link, just give me 5 minutes, I'll share the link only here, like for the sample memorials. Vakula, please take all the questions that you might get.
Yeah, in the meantime, do you have any more questions? You can even raise your hands and ask it away and have an interaction with us. The floor is open for questions. Anything apart from what we had discussed in the workshop, also you're open to ask. But if it pertains to drafting of memorials and oral arguments, do wait because we have a separate workshop dedicated for that purpose. But apart from that, if you have any questions, you can post them.
That's why I've sent the link through which you can access different memorials. Though referring to the last year's FIM memorials should be more than sufficient because majority of the problems that you'll encounter post FIM would be way more complicated than your FIM problem because they usually involve a lot of concepts of law and they are much more complicated. They are not for the purpose of induction. So yeah, that is there. Uh, you should start your research from the moot prop itself, Divij, to be fair. Like you start with your moot prop, you start reading it, you start understanding it. That is where you figure out the bare acts that you have to refer to or the laws or statutes that you have to refer to. And post that you move forward to the commentaries and find the relevant cases and then you move forward. You can refer to blogs or anything to understand the concept better, but then you go to the cases itself. Like the case laws are very important. So you jump to the case laws then. What kind of books should we refer? So usually there are some very well-known commentaries depending upon the area of law that you're referring to, which have often been referred by the court itself. Uh, like in family law, there is Mullah, and in contracts also there is Mullah. There is other few commentaries like Avtar Singh. So all of these commentaries are there. You can just do a Google search, you'll figure out there are a lot of commentaries which are very well recognized for that particular area of law. In criminal law, as Vakula mentioned, there's PSA Pillai, there's KD Gore. So yeah, there are some well-known commentaries you'll figure out, and most of them, like depending upon what you like, you should decide which commentary do you wish to follow because there are a lot of commentaries out there. So yeah.
Any more questions? Is overall, but it is advised that each one of you who attended the workshop today give it a shot. The judges who would be assessing you are all going to be lawyers who are practicing. You will make a connection, you might get to know where they're coming from. You get an exposure. It's like try it. You get to see what your future looks like by participating in this. And becoming a member of the Moot Coach Society is going to be a gateway into a lot of opportunities that await you. So do make sure that you utilize this opportunity. Okay, if you have any queries, you can reach out to us. I think Yukti has shared the mail address with you in the chat. You can reach out to us in case of any queries. If you have a problem specific query, then you can put it on the Google form that we have shared. Follow our Facebook page, Instagram page if you have not followed it already for any updates so that you don't miss out on our workshop dates. There are 2 more workshops that are yet to be conducted. So just keep following MCS page, and if you have any doubts, you can reach out to us in case of any time. In case of any doubts. I'm assuming that there aren't any more questions.
Yeah, I don't think there are any more questions. So yes.
We'll wait for another 1 minute and then you can all start leaving the meeting. Thank you so much for attending the workshop. I knew that you have Holi today, but you guys have managed to attend. We appreciate that dedication. Thank you, guys.
Thank you very much for conducting this session.
Thank you, Bhuvnesh. Thank you, everyone.